Yes.
For admission, item number 1.
May I please, Your Lordship? This intra-court appeal has come up before Your Lordship for consideration since the learned single judge has directed the respondent number 2 to be promoted with effect from 23/7/2024,
Yes.
wherein the other respondent 3 to 7 were promoted.
Yes.
My Lord, if I may take Your Lordship to the impugned judgment and order, there is a page 1 to 22. Now, the operative portion of the learned single judge order is at page 21.
Yes.
With Your Lordship permission, at para 29, if I may be permitted to read the...
Read the paragraph. Yes.
Yes, my Lord. With Your Lordship permission, from the above discussion and findings, this court is constrained to set aside the impugned notification dated 23/7/2024 in WPC number 94 of 2024 to the extent that the petitioner number 2 should be considered for promotion to the post of assistant grade 2 along with the other eligible candidates with retrospective effect.
That's right. We have understood that.
My Lord.
Now, what is your ground of challenge?
Now, my Lord, our promotion from AG1 to AG2 is governed by Rule 23 of the Staff Service Rules 2024, my Lord. Your Lordship will come at page 25 of the book. That is the rules relating to promotion, and at page 27. This present case is under Channel B, page 27 of the book, my Lord. Yes. Yeah. Now, with Your Lordship permission, I'll read this Channel B. There are 2 channels, and the instant case is covered by this Channel B. Seniority, performance, etc. The weightage to performance, seniority, and interview will be in the ratio
So
of...
therefore, the ratio of performance would be 45.
Yes, my Lord.
The ratio of seniority would be 20.
Yes, my Lord.
And interview would be 35.
Yes, my Lord.
Which is precisely the same in channel A,
Yes, my Lord.
except the written test.
Yes, there is no written test under
That's
channel.
right. We have followed
Well,
that. So except this.
Yes.
So therefore, your argument perhaps is that this being equal, seniority should have been given preference.
No, that is not my argument. That is the argument of the respondent. my Lord. Read petition.
Okay, that's the.
Now, my argument is that, my
Oh,
Lord.
you have lost.
I have lost and I've
You
come
were
before you.
promoted. You now stand placed junior to the respondents.
Yes, my Lord.
Yes.
Now, my point is that under...
Lordship, he is representing the Apex Bank, not the
Actually, you are for the
respondents.
Apex Bank.
Apex Bank.
And who appears for the parties?
Private
The second
respondent.
private respondents?
Private respondent, they did not come forward, my Lord.
No, we will hear it together, no?
Yes, my Lord.
Item number 2.
Who is the writ petitioner?
Writ-
Writ petitioner?
Read petition in item number 2 is the same.
Where are the private respondents?
Private
You are appearing
respondents,
as a respondent here. You are appearing.
In this case, my Lord, 1 and 2.
In this case. And
Yes.
the other case?
The other case also.
All right. So we'll hear it together.
Pro forma, they did not come.
The private respondents in the writ petition, where are they?
They were experted in the before the learned single judge. They have no interest, actually, my Lord.
But then they'll be affected. There was some note here. What happened to that? No. There's some note which I made while I went to the file. I don't know. They've taken it. Is it your file? Okay, doesn't matter. It's not there. It's not there. I saw that. Yes.
My Lord, one of my grounds is that
Yes.
under subclause 8 of page 27, here minimum qualifying marks to be considered for promotion will be 50% of aggregate. It is the stand of the private respondent that they have secured 50% aggregate. Now, if your Lordship will continue, I'll continue reading. Selection shall be done on the basis of combined marks of written test, performance, seniority, and interview. It is both under Channel A and Channel B. That means
Where are you reading?
clause 8 of page 27 under
Yes.
Channel B.
Yes. Qualifying marks will be considered for promotion, will be 50% of the aggregate.
Yes. And the final selection shall be done on the basis of combined marks of written test, performance, seniority, and interview. Now, the learned single judge overconsume itself with the principle of merit come seniority and seniority come merit.
But why are there two channels?
Now, in Channel A,
Now that argument is very good, but then you must tell us why there are two channels available for promotion.
yes, my lord.
One is merit cum seniority, that is understandable.
Yes, my lord.
Merit is the everything.
Yes.
Now channel B is seniority cum merit.
Seniority.
But then you have liquidated it, you have diluted it, and you have made it like channel A only.
Correct, my lord. Even seniority precedes performance, but the marks, the criteria is performance is 45 and seniority is 20. Now there is a judgment. There is a judgment of the Honorable Supreme Court.
Forget about judgments. Let us first have
Yes,
the facts
ma'am.
clear. Judgments
Yes.
we will see.
Yes, ma'am.
You will refer to Samantha Rai.
Ravi Kumar. K. Samantara also. ma'am.
Samantha Rai is the judgment which tells you that notwithstanding anything, if the rules are specific,
Yes, my lord.
then you don't need to go elsewhere.
Yes, most respectfully, I agree with your lordship.
But why channel B?
Now, in Channel B, they don't have to write written examination. So the performance, they give primacy, they give primacy over performance because the employee of the bank has to be efficient. That is why, my lord. And in fact, my lord, these rules has not been challenged by the respondent.
No.
They have accepted these rules.
Just a minute.
Right, my lord.
Now please come to Appendix 1 of the rules.
My lord.
This is promotion from technical subordinate grade 1 to grade 2. This is with respect to some of the writ petitioners.
No, my lord. We are concerned with assistant grade to grade 2. Appendix 3. Page 112.
Appendix 3.
Yes, page 112.
Yes. So an employee in the assistant grade 1 having rendered confirmed continuous satisfactory service or to the bank for 5 years will be eligible for promotion to grade 2 through seniority channel.
Yes, my lord.
What happens? The rule has to be challenged. These two don't go hand in hand. The appendix and rule 23, they are contradictory so far as weightage is concerned.
My lord.
Mr. Advocate General, you don't have to do anything with this matter.
No.
What is to be done? These rules have to be challenged by the writ petitioners, otherwise.
Rule hasn't challenged.
No, rule has not been challenged.
See, there are two things here. There are two channels of promotion. A is merit cum seniority, B is seniority cum merit. But then the interpretation, the details, what has been provided in Rule 23, it is a composite assessment of performance, seniority and interview. And the minimum aggregate is 50. So therefore, this is similar to seniority cum merit or merit cum seniority. But then this doesn't go hand in hand with Appendix 3, which specifies that for promotion to grade 2, from the assistant grade 1, it will follow the seniority channel. The appendix, and it says according to the appendix, let's see rule B, promotion. The promotion to all grades in different categories. Come to 19, section B, promotion. Promotion to all grades in different categories would be subject to availability of vacancy made in accordance with the rules of promotion so and so, and on the basis of written test, performance, seniority and interview of the employee concerned, appendix 1 to appendix 11. So this has to follow the appendix, and the appendix says that it has to follow the seniority channel.
Yes, my lord.
So therefore, marks, all right, one has to, if this is strictly to be followed, then marks and then whoever is senior. So once you clear the cut-off marks, the seniority channel has to be applied, unfortunately, because appendix, how do you reconcile appendix 3 with section 23?
Now, my lord, here, if we look at channel B,
Now this, you answer this question
Yes, my
first, then
lord.
we go to other.
yes, my lord.
Unless we are satisfied about one aspect of the matter, why to go and why to look at it from, we can look at it from different angles,
No, there
but
is
then
a-
you have to first answer this.
Yes, correct, my lord. That is under Rule 23, my lord. Now, here, even though the heading channel B says seniority, performance, etc., it gives primacy to performance because the weightage of marks under performance
That's all
is
right,
45.
we understand that.
Well-
Therefore, we said that for all practical purposes, the distribution of marks with respect to performance, seniority and interview,
Yes.
it has been kept constant in channel A and channel B.
Yes, my lord.
Correct?
Yes.
So that is not being questioned, but it is dependent on what has been decided in appendix 3.
Yes, my lord.
So appendix 3 says seniority channel.
Now-
In that case, how do you find fault with the judgment of the single judge?
Now, my submission is that I would like to impress upon your lordship, this seniority channel is not a seniority simpliciter. It gives primacy to performance as well. I will take the help of this Samantarai case.
The moment you have allotted marks,
Yes.
and you have kept the minimum qualifying marks.
Yes.
So a person to get into the channel of seniority, he should be above the cutoff marks and thereafter seniority. That's the principle. And because you have specified it like this.
Yes.
Now, merit cum seniority is that merit has to be given precedence. If merit is equal, then seniority.
Yes, ma'am.
Conversely, in seniority cum merit, a person cannot claim to be promoted only on ground of seniority.
Yes, my lord.
He should not be bad. That is the only requirement. Now, this you have made it very clear by providing marks, overall marks and the cutoff marks. See, if you read 23 alone, you may be right there. If you read 23 alone, you may be right there.
Yes.
But you will have to read it subject to 19(1)(a), Rule 23 and Appendix 3. All three read together makes the judgment of the single judge unassailable. Now let's see what Samantarai says. AC ठंडा करो. Lessen the temperature. AC should be more cold.
My lord, I'll come straight to para 11, page 291.
Para?
Yeah, para 11. Page 291. With your lordship permission, I'll read this.
That's right.
While laying down the promotion policy or rule, it is always open to the employer to specify the area and parameter of weightage to be given in respect of merit and seniority separately, so long as policy is not colorable exercise of power, nor has the effect of violating any statutory scope of interference and other relatable matters. The decision in BV Shivaya case is clearly
Now,
distinguishable.
neither Sivaya would control the field here,
Yes.
nor
Now-
Samantarai.
Yes, my lord.
What you can cull out from Samantarai is that if there is any term fixed in the rules,
Yes, my lord.
adding anything further would be impermissible.
My lord.
So therefore, I mean, I have condense the argument for you or for the other side to this small slender point,
Yes,
that
ma'am.
if you read 19(1)(b), 19(23)(2)(b) and appendix 3, what comes out is that even though you have given marks, you have specified the marks, but then if it is a seniority channel, once the cutoff marks has been obtained, seniority has to be given due weightage. This is what appendix 3 says.
Yes, my lord.
Otherwise, what is the purpose of these two channels? But for, dispensation with writing of a test, which is there in the merit.
So it's basically seniority from the,
23B.
when you read it with this appendix.
Any other argument?
Yes, my lord. Since the respondent has accepted the criteria adopted and the channel B, wherein they have participated in the selection process without any protest, now they cannot approach
This
the
argument cannot be a sequitur to what we have said.
my lord. Now they have not challenged the rules.
Let
If-
them not challenge the rules, so therefore the rules which are there, now they don't require, the writ petitioners do not require, respondents here, they don't require to challenge the rules. They are going by the rules. They are pleading by the rules. We are reading the rules in the manner in which we deem it appropriate to read it.
Allow me to have a contrary view of a lordship with regard to that seniority channel that appears in the appendix.
3.
Now, my lord, rule 23 and that channel B cannot be subservient to the appendix, because under channel B, primacy is given to performance, and seniority alone cannot be determinative factor.
That's
my
an
lord.
argument which is very difficult to accept. That's an argument which is very difficult to accept. We will tell you why. These are for two reasons. Because of the presence of two channels,
My lord.
number one, and number two, the rules making it very, very clear that it will be subject to the provisions contained in appendix 3. We cannot say that one would supersede the other. It has to be read harmoniously. Otherwise, appendix 3 is rendered completely otiose. No necessity. It has to be construed harmoniously. And that's how we consider it to be. And that's how the single judge has, though of course the single judge has not taken into account these aspects, has talked about basic principle of seniority cum merit. We are adding gloss over it.
With-
And we are saying that appendix 3 makes it very clear.
My lord, allow me to make my further submission with regard to merit cum seniority or seniority cum merit, or the other aspect which has been discussed by the Honorable Supreme Court in Ravi Kumar dan Suklam Mahate case. I have provided an advance copy of the judgment, my lord.
All judgments tell you same things. No, judgment says that seniority merit comes seniority, merit comes first. If two persons have equal merit, seniority will be considered.
Yes, my lord.
In seniority come merit, a person only because of his seniority will not get promoted. He has to be good. There cannot be any competition who is better. But that merit also plays a part. Therefore, the primacy is of seniority. Merit takes a backseat. Backseat in the sense that he has to be good, but he need not be the best. This is what all judgments right from 1968 till 2014, the same principle, and especially B. Sivaya also, this principle was expounded. Samantara says that if the rules are clear, then all this confusion should not arise. The rules have to be followed.
Now, my lord, allow me to cite the Supreme Court judgment in Ravi Kumar case. It has elaborately dealt with that
Like
principle, my lord.
Ravi Kumar. What happened to my notes? I made some notes here. Yes, Ravi Kumar.
My Lord,
The latest.
allow me to start from page 473, para 99.
Para 99.
Yes, my Lord.
Yes.
With your Lordship permission, the underlying reason why the aforesaid postulation ought not to be understood as mandatory stems from the very fact
I
that...
think you do better by reading para 98.
Yes, my Lord. The various decisions of this court have only developed upon the principles of merit cum seniority and seniority cum merit by explaining the criteria that may be postulated within the framework of these principles. For the purpose of promotion, the scope of the aforesaid principle is summarized below. The principle of seniority cum merit postulates that minimum requirement of merit and suitability which is necessary for the higher post can be prescribed for the purpose of promotion. Comparative assessment amongst the candidates is not required. Seniority of a candidate is not a determinative factor for promotion but has a predominant role. Upon fulfilling the minimum qualifications, promotion must be based on inter-se seniority. The
Now,
princi-
this is what we are suggesting to
yes,
you
yes, my Lord.
for the reason of Appendix 3 and the two channels.
Yes, my Lord.
One merit and the other seniority. Now read the first interpretation of it. Minimum requirement of merit and suitability,
Yes, my Lord.
which is crossing the threshold limit of marks, which is necessary for higher post, can be prescribed for the purposes of promotion. And this is what you've done in awarding marks with different weightage. So that is not going to control. Anyway, read next. The
And-
principle of merit cum seniority.
Yes, my Lord. Merit plays a predominant role in, and seniority alone cannot be given primacy. Comparative assessment of merit is a crucial, though not a mandatory factor. At subclause 3, only where merit is equal in all respect can inter-se seniority be considered, meaning that the junior candidate can be promoted over the senior if the junior is more meritorious. At para 99, the underlying reason why the aforesaid postulation ought not to be understood as mandatory, my Lord, stems from the very fact that they are not a result of a legislative creation, but rather one of judicial interpretation whilst dealing with different promotion policies, different service conditions, the varied nature and requirement of posts, and more importantly, different set of rules. Since these postulations have been laid down in different contexts and varied facts, it would be preposterous to say that such postulation will apply uniformly to all services and matters of promotion, including the judicial services. At para 100, the principles of merit cum seniority and seniority cum merit should by no means be regarded as rigid or inflexible in nature. Otherwise, this judicial connotation would effectively assume the character of statutory stipulation laid down through various judicial pronouncements and would become applicable to all types of services, posts, and promotions. This would lead to the transgression by the judiciary in the realms of policy making. I'll skip to para 104, my Lord, page 474. The fluid nature of the principles of merit cum seniority and seniority cum merit is further evinced by the decision of this court in case Samantarai, wherein although the policy stipulated that promotion would be on the basis of seniority cum merit, yet this court, after going through the elaborate promotion policy, held that a third mode of promotion, known as the hybrid mode of promotion, has come to be recognized by this court, wherein it is open for the employer to specify the area and parameter of weight required to be given to merit and seniority for the purpose of promotion. It was further held that it was always open for the employer or the selection body to decide and stipulate their own criteria for judging the claims on the principles of seniority cum merit or merit cum seniority, depending upon the class, category, and nature of post and the requirements of efficiency. What can be discerned from the aforesaid is that wherever the expression merit cum seniority or seniority cum merit has been supplemented by an elaborate promotion policy or statutory rules clearly indicating the parameters on which promotion are to be made, The mode of promotion assumes the character of a hybrid or dynamic mode of promotion as held in case Samantarai at para 106. In such scenario, these principles serve as a beacon for the selection body which, in exercise of its delegated legislative powers, can formulate policies and lay down different criteria and conditions of assessment for the purpose of promotion. It does so by providing the selection body with the tools for formulating the promotion policy in the form of the aforementioned postulation or criteria which are permissible under these principles. Thereafter, the selection body can, as a conscious choice, decide the criteria it deems necessary.
All right. Yeah.
My Lord.
Yes. Anything else?
If Your Lordship allow me to continue with the
No,
judgment.
no. You have to tell us the principle. Reading it, or I mean,
Here,
reading through the judgment is not necessary. We have followed the principles.
I need to read para 108 with Your Lordship permission, my Lord. Page 475.
We just read para 108, which says
108.
that it is flexible.
Yes, my Lord. So,
These are flexible and fluid concepts akin to broad principles within which actual promotion policy may be formulated.
yes, my Lord.
Now, this is how you have formulated.
Yes,
now,
ma'am.
let me put it differently to you. This is for you to understand.
Ma'am.
We are very clear in our minds now.
Yes.
Now, you must make a distinction between the mode of promotion and the modality of promotion. 23 deals with modality. Appendix 3 deals with mode. These are two different concepts. Can't conflate the two. That's what the substratum of the judgment is. And if that be so, because of the clarity of the rule-making body, when it formulated from 19 to 23 and Appendix 1 to 9, with specific stipulation in Appendix 3 that this promotion shall follow the seniority channel, these principles go to the background. So, when you award more marks on performance, some marks on interview, and lesser marks for seniority, even in channel B, that's a modality, not a mode. That's a modality for assessing the merit, because seniority channel does not say that a meritless person must be taken in. The comparative assessment of merit may not be made, and therefore they have fixed a benchmark of 50. So suppose somebody gets 68.5, somebody gets 70, but 68.5 marks is obtained by a person who is senior to one who has obtained 70 in the channel of seniority. That model of promotion, I think the person who has got 68.5, that is above 50%, and senior, he steals the march. Otherwise, there is no purpose of having two models. All right, we are very clear. If you want to read anything further, read.
I beg to differ with Your Lordship on that. Since under Rule 23, it says that aggregate mark is only for the purpose of consideration for promotion. Now, if we read that Rule 23 under Channel B, selection shall be done on the basis of written test performance.
So basically there are two views
Yes.
according to you.
Yes, my
If
Lord.
there are two views and one view has been taken by the single judge,
Yes.
then should we substitute our views for that of the single judge?
I go a step further. This is the only view possible by reading of the rules.
Now, I'm relying upon the Honorable Supreme Court judgment, which says that there can be a hybrid mode also.
There can be a hybrid mode, Samantarai says,
Yes.
but hybrid mode only when everything is absent. When the rules are clear, where is the question of hybrid mode? And this is a hybrid mode. The modality has been discussed. We can say that. Mode and modality are two different things.
Not to be
Mode
ta-
is seniority come merit. Modality is assessing marks for the merit. Basic threshold marks. एक ही argument है, चलो.
Not to be tedious to Your Lordship, this is my last submission, my Lord. Since the private respondent has not challenged the rules
No, not
and the
required.
criteria adopted,
Not
now
required.
they cannot come before the learned single judge challenging the
Not required, Mr. What is his name? Mr. Zwala. Mr. Zwala. You've made a good argument, but then we are with you on this.
my Lord.
If we read 23, If we read 23 along with 19 and appendix 3, we need to change our view.
I bow down. It is my duty to make a submission.
That's right. Yes, the other case. Let's see how you defend, how you
Lordship.
challenge the single judge's opinion.
No, he is supporting the single.
He's
He is challenging.
he's the bank, and
Yeah,
private respondents have not
They have
come.
not- they have not-
Private respondents have not
The
come,
private respondents in the writ petition have not come. Even in the writ petition, they
and he is for.
He is for the
I'm for the writ petitioner.
What, you don't have to do anything. Take it up. And what is the second appeal? One is by bank and the other?
Same, both are by bank.
All right. We have heard both the appeals have been taken up together and are being disposed of by this common judgment. We have heard Sri C. So-and-so Zwala for the appellant / the Mizoram Cooperative Apex Bank Limited and another, and Mr. C. Juava, learned senior advocate, for the respondents / writ petitioners. The challenge herein is to the judgment dated 14/8/2025, passed by a learned single judge of this court in WPC number 94 of 2024 and WPC number 99 of 2024, both of which writ petitions were decided by a composite judgment. The writ petitioners in WPC number 94 of 2024 were confirmed to the post of assistant grade 1 on 6/2/2025. Stop. A provisional inter-C seniority list of assistant grade 1 was made by notification dated 27/2/2024, in which other persons placed below the writ petitioners. No, it was made by notification dated 27/2/2024, in which the writ petitioners were placed high in the merit list. Stop. Later, "14 posts of AG assistant grade 2 which had fallen vacant was required to be filled up, for which the writ petitioners had applied. They were amongst the eligible candidates, but the final notification dated 23/7/2024 displayed that they were ousted from the consideration, and the promotion was given to the juniors in AG 2 in level 8 of pay matrix of the bank. Similarly, the writ petitioners in WPC number 99 of 2024 were also aggrieved by the notification dated 23/7/2024, by which juniors to them were given promotion to the post of junior management grade from AG grade 2, assistant grade 2 in the bank, both the promotions were undertaken under channel B, which provided that it shall be based on the principle of seniority cum merit. In order to understand the challenge of the appellants, it would be necessary to first refer to the relevant rules, relevant sections of the Mizoram Cooperative Apex Bank Staff Service Amendment Rules 2024. Rule 19 clearly provides that promotion to all grades in different categories would be subject to availability of vacancy, made in accordance with the rules of promotion framed by the board/executive committee from time to time, and on the basis of written test, performance, seniority, and interview of the employee concerned. Bracket Appendix 1 to Appendix 11. Subclause D of Rule 19(1) further specifies that where there are two or more promotees at the same time from the same grade through merit cum seniority channel and seniority channel, their seniority will be fixed, giving priority to merit cum seniority channel in a proportionate ratio of 2:1. Next. Rule 23 clearly specifies the modality relating to promotion. 23(1) provides that in case of any two employees securing equal marks, the final selection shall be made on the basis of inter-C seniority. In the same rule, two channels have been specified, namely channel A and channel B, dealing with merit cum seniority and seniority cum merit model respectively. In both the channels, the weight is given to performance, seniority, and interview have been provided in the ratio of 45:20:35. The only difference between these two channels is that for promotion in channel A, there shall be a written test which has not been provided for in channel B.
And it carries 100 marks.
For a maximum of 100 marks, in both the channels, the minimum qualifying marks to be considered for promotion will be 50% of the aggregate, and selection would be made on the basis of combined marks of written test, performance, seniority, and interview. Perforce, these rules have to be read with Appendix 3,
112.
which deals with promotion from assistant grade 1 to grade 2 in channel B. First, Rule 5, section 5.1 of the appendix 3 mandates that an employee in the assistant grade 1 having rendered confirmed continuous satisfactory service to the bank for 5 years will be eligible for promotion to grade 2 through seniority channel. Thus, a bare reading of Rule 19, 23 and Appendix 3 make it very obvious that there are two channels of promotion available under the rules. Channel A, semicolon, channel A, which is to follow the seniority, which is to follow the merit cum seniority model, whereas channel B is for seniority cum merit. However, the modality for assessment which has been provided for both the channels is almost similar, except for written test which would be conducted for channel A promotion and not for channel B promotion. So far as weightage to performance, seniority and interview is concerned, in both the channels, the ratio of weightage has been provided as 45:20:35. The only sequitur of this is that in both seniority in both the channels, performance would be marked on the basis of marks obtained by a candidate / aspirant in the ratio specified, but due weightage shall be given to merit in channel A and to seniority in channel B. In the aforenoted two writ petitions, which was disposed of by the learned single judge, the writ petitioners had obtained the cut-off marks, had obtained much higher than the cut-off marks of 50%, but they were not promoted solely on the ground that more meritorious candidates were available who incidentally were junior to the writ petitioners. The learned single judge, after having discussed the law with respect to various modes of promotion, the binary mode of promotion, namely the merit model and the seniority model, found that when the writ petitioners / respondents herein had obtained more than the cut-off marks of 50%, then seniority had to be reckoned for any promotion in channel B. After going through the case laws, the learned single judge concluded that since the writ petitioners / respondents had scored the minimum qualification marks to be considered for promotion, which is 50% of the aggregate, and the promotion being carried out in channel B, which is the seniority model, it was absolutely unjustified to exclude them from promotion and promote the juniors who perhaps had secured more marks in the assessment, which was a combined assessment of performance, merit, performance, seniority, and interview. They this is how I do.
So the grant schedule that basically said that it's not a hybrid mode of conduct.
We'll deal with that when we come to the hybrid dynamic mode. That I'll do and I'll discuss there. In Ravi Kumar, Dhansukhlal Mehta and others versus High Court of Gujarat and others, 2024-11 SCC 424. Has explained the principle of seniority cum merit and merit cum seniority, which are conceptually different. First up, in seniority cum merit, minimum requirement of merit and suitability, which is necessary for the higher post, can be prescribed for the purposes of promotion. First up, in this model, comparative assessment amongst candidates is not required. First up, seniority of a candidate is not only the determinative factor for promotion, but it has a predominant role. First up, this therefore implies that upon fulfilling the minimum qualification, promotions would be based on inter-C seniority. The merit cum seniority model postulates that merit plays a predominant role in, and seniority alone cannot be given primacy. First up, in this model, comparative assessment of merit is crucial but not a mandatory factor. This therefore implies that only where merit is equal in all respects can inter-C seniority be considered. In other words, a junior candidate could be promoted over the senior if the junior is more meritorious. However, after having explained the concept, the Supreme Court very pithily held that these models are by no means to be regarded as rigid or inflexible in nature. Otherwise, these judicial connotations would effectively assume the character of statutory stipulation laid down through various judicial pronouncements and would become applicable to all types of services, posts and promotions, thereby leading to the transgression by the judiciary into the realm of policy making. What the Supreme Court emphasized was that these models could be interpreted in the aforenoted manner in the absence of any specific stipulation in the rules governing the field of promotion. governing the field of promotion. First up. While the learned single judge also castigated the decision of the respondents in coming to the conclusion that the writ petitioners were rightly, in coming to the conclusion, what have I said? Just the last line.
Appellant.
No. While the learned single judge castigated the decision of the appellant in excluding the writ petitioners from being promoted, it held that dehors the rules governing the field, the appellant had applied the hybrid model which takes into account both the modalities of merit cum seniority and seniority cum merit. With respect to this aspect of the matter, we deem it appropriate to state that both the models are fluid in nature and therefore many a times while going through the promotion policy, the courts have recognized a third mode of promotion, namely the hybrid mode of promotion, where it is open for the employer to specify the area and parameter of weight required to be given to merit and seniority for the purposes of promotion. It is precisely for this reason that the Supreme Court in case Samantarai versus National Insurance Company Limited 2004 9 SCC 286 held that it is always open for the employer or the selection body to decide and stipulate their own criteria for adjudging the claims on the principles of seniority cum merit or merit cum seniority, depending upon the class, category and nature of post and the requirements of efficiency. In the present case, it appears that there is an elaborate promotion policy by way of statutory rules clearly indicating the parameters on which promotions are to be made. In a way, when provision has been made for the modality of assessment of the respective merit and seniority, comma, the rules in question provide a somewhat hybrid model, which is capable of creating confusion while deciding the promotion to the employees. The confusion can be sorted out by understanding that there is an essential difference between the modes of promotion and the modalities of promotion. The mode of promotion would include either the merit model or the seniority model, which in the present set of rules is channel A and B respectively. First, the modality for both the models has been prescribed. First off, in channel A, which deals with merit model, comma, assessment of merit is done on a scale of 100 by awarding weightage in the ratio, by awarding weightage to written test, performance, seniority and interview in the scale of 100 is to 45 is to 20 is to 35. First up. Sans the written test requirement in channel B, the modality remains the same for performance, seniority and interview, which again is in the ratio of 45 is to 20 is to 35. Thus, to some extent, the rules herein could be called a hybrid rule of promotion, but specifying in Appendix 3 that the promotion from grade 1 to grade 2 or from grade 2 to JMG grade would follow the seniority channel of seniority channel B, then it would only be in consonance with and in obedience to the rules that after the candidates acquire the minimum qualifying marks in assessment, comma, seniority is given appropriate weightage. First up, not reading the rules in this manner would render the stipulation in Appendix 3 to be redundant or absolutely obtuse. First up, having explained thus, we do not find that the learned single judge erred in setting aside the notification dated (23/7/24). Where is that?
Page 20, para 29.
What did I say? (24) and issuing direction for consideration of respondents for promotion to the post of assistant grade 2 along with other eligible candidates with retrospective effect from 23/7/2024, along with other service benefits. And
That is in connection with 94 of 20.
promotion to the and promotion to the respondents to the post of junior management grade, along with the others eligible candidates, again from the retrospective date of 23/7/2024, with all the service benefits. Full stop. For the reasons explained above, we find no merit in the appeals which are dismissed.
Highly obliged. Lordship, may I make one statement? The fact that since the private respondents in the writ petition, they were duly served notice and they were informed to appear before the Honorable Court, but they declined to
That's all right. We
and
have,
now the matter has been taken up by the Apex Bank.
Mr. Zuala, the difficulty is that we are not altering the judgment.
That's true.
Therefore, it is not necessary. If we alter the judgment, it's all the more necessary.
Item 3.
ऊपर में लिखवा देना, just dictate that the respondents have not appeared despite notice. You're right, that despite notice, the private respondents in the appeals have not appeared. Last minute, we take notice of the fact that private respondents, despite issuance of notice, have declined to appear. However, since the judgment impugned in the two appeals is not being altered, it would make no difference, or something like that will delay it. Yes.
Item 3.
Yes.
This matter pertains to allotment of land
Yes.
for the
Oh.
district and sessions court.
Just for me.
So they have given it to us.
I know.
Mr. Advocate General, we are in contemplation of something else. Now, we are not insisting for that land to be given to us straight away, because there is possibility of another land, a better located land, to be given to us. So in that case, we don't pass any order today.
But my Lord Milite, may I be allowed to submit that in view of the earlier decision taken by the High Court and the Bar Association and the District and Sessions Judge, a particular land has already been allotted
That's what we are saying, no?
and now something new has come up.
That's right.
Correct.
Correct. That's what we are saying. So therefore, in order to avoid and skirt away from all controversies for future, we are not passing any order today. Let us see what happens administratively later. Because the other land which is likely to come to us is better. And I think the best should be given to the courts.
And then again, something best may also come up after this.
We will not
You
such
don't-
comparative
Your Lordship
assessment.
don't know.
Presently, we don't pass any order today.
My lord.
Let this matter come up for
Lordship.
consideration on, give a date sometime.
Yes, yes,
After Christmas vacation,
Christmas, after 3 weeks?
it
So
will
that-
take time.
No, it won't take time.
After 3 weeks. Let's see, we'll adjourn it again.
Lordship.
26 November.
Just record the names of this, the AG is present.
Record.
AG and Mr. Malhotra.
Item 4.
Mr.
Partly.
We may not spell it out now, but there is a reason.
Yes, sir.
Item 5.
Please, Your Lordship, the petitioner herein are the Bachelor of Engineering, Civil Engineering, degree holder. And state respondent had advertised the post of JE.
And the rules have now restricted the entry only to the diploma holder.
No, that's an apprehension. Now, tell me one thing,
Yes.
MS Dinari.
Yes.
This order dated 26/3/2025 appears to have been passed on the apprehension of these civil engineers.
Yes.
Are you really stopping them?
No, I'm
I
participating.
mean, are they
in
being
the-
stopped? State of Mizoram. Yes, Mr. Advocate General.
The exams have been held, I'm told. But
The exams
results
have
are
been held.
Yes, we are also.
You have also appeared.
Yeah.
May I assist the
By
court?
this-
My lord, I'm
what do you
standing
intend
counsel
to
for
do?
NPSC. I know the status, the present status. I'm standing counsel for Mizoram Public Service Commission.
What did you say?
Public Service Commission Council.
I think he's a learned counsel appearing for the
They've
MPSC.
conducted the test.
You have
We
conducted.
have, Your Lordship, we have conducted everything. Now, as per this interim court order, we upheld the results. Only we are waiting outcome of these verdicts of this judgment, this case. Now we can pronounce
This is the
the
challenge
result.
to
and
the
it-
rules. Now, we would like to hear from the Advocate General, what does he intend to do? Now, these are graduates having higher qualification than
Yes, madam.
diploma holders.
I
But
agree.
are you disputing? Are you
Yeah,
supporting this, that
The
they ought to
reason,
be considered?
the reason, my lord, if I
No,
can,
we
if I-
don't want to get into that, Mr.
no, the reason why we are preferring the diploma holders. There's a reason for that. And for that, my lord, if I can take your lordship to my affidavit in page 5. Page 5 of my affidavit. Paragraph 11.
Your respond number 1 to 5.
Yes, my lord. Paragraph 11. That with regard to the statements made in paragraphs 10 of the writ petition, I say that while it is acknowledged that the candidates possessing a degree in civil engineering may possess advanced qualifications compared to those holding diploma, it has been observed that degree holders appointed to the post of junior engineer frequently seek opportunities for higher position and subsequently resign from their posts resulting in frequent vacancies. This trend has posed significant challenge for the department in terms of maintaining continuity and thereby has necessitated related recruitment process, thereby causing administrative hardship. Furthermore, the department has noted that the presence of the degree holders has on occasion led to workplace discord and issues of professional hierarchy. In view of these considerations, the eligibility criteria have been restricted to diploma holders in civil engineering to ensure stability and efficiency in the functioning of the department. As such, for the new recruitment arising vacated posts by degree holder, the department has to go through a long process in obtaining government approval for filling up the vacant posts. This has hampered ongoing works of the department.
We have followed.
My lord, so this is the basic reason. And this is a chart, my lord, thereafter, from 2016 to 2000 till date, my lord. 15 degree holders have already tendered their resignation and have left. Now, my lord, in order to ensure that there is a continuity,
You should have taken another ground to buttress your reason. Another ground is that a degree and a degree in civil engineering and a diploma in civil engineering are two different courses, and it is not in the same line, same channel of higher education. That ground has weighed with the Supreme Court. There is a
no,
judgment.
I am referring to the Supreme Court judgment. I am coming to that, my lord. I am coming to that. Thereafter, my lord, paragraph 12 also, that with regard to the statements made in paragraph number 11 of the petition, I say that it is true that the omission of the word "at least" in the new recruitment rules has resulted the debarment of the degree holders from applying for the post.
No, then again, we have some objection with this.
With this,
When you say at least, that means persons with degree also can apply who have diploma.
so that
So
is
you-
the objection.
You don't completely exclude them, but you restrict it to diploma holders because that is the basic qualification.
That is exactly what the Supreme Court is saying, that you exclude them.
No. Supreme Court in Jyoti KK, the case you have cited
My lord,
in your
my lord,
affidavit.
yes, my lord. Paragraph 9.
There are many other decisions. One. Jyoti KK is, we have followed, but Jyoti KK says that persons of higher qualification can apply provided the higher qualification is in the same line of learning. Suppose the
Right.
basic threshold qualification is graduation. Would you stop postgraduate candidates from appearing because a postgraduate has to be a graduate? So therefore, this is the argument. You have not taken note of the latest judgments of the Supreme Court, which has originated from the state of Bihar, from the state of West Bengal. I'm forgetting the names. I'm not good at names. It says that it should be in the same channel. So an argument was raised by degree holders sometimes back in different circumstances,
Not sure.
that even in degree, the subjects which are taught are the same subjects which are taught in diploma. But then it was found that diploma has a specialized course, it has on-field training and many other things which make them more suitable for the job. That the reasoning given by you is that these engineering graduates,
They opt for promotions and they
go
leave
for-
their jobs.
They go for greener pastures because it is available to them.
Yes.
But in that case, while doing so, you make the entire vacancy filled up by diploma holders. Or is it a good way to handle it? You could have said that anybody having a diploma but yet has a higher degree could apply, and we will only consider his diploma qualification for the purposes. I think that was a better way of handling it, but nonetheless, we have nothing to say on your wisdom. That's for the state
This
to
is-
decide. The employer knows. Anyway, yes, Ms. Denari, what do you have to say?
Your Lordship, as you know, Your Lordship, kindly see the chart prepared by me, page 42 of my petition. How the post was...
Page 42.
42 of my petition. Your Lordship, here you see the name of the post, sanction post. Here, as section assistant, 207, 100% from diploma holders. And ZE Civil, 369 sanction post, 65 from diploma holder and 35 from section assistant promotion. That is, all of them are from diploma holder. So from degree holder, MES junior, 150 posts, 65% only, that is 97 posts. See, altogether, 726 posts are there, wherein the degree holder can occupy only 97 posts. So it's not fair. Earlier, Your Lordship, in JE Civil, we are allowed to participate in the degree, for the post of JE Civil. And even the previous 2017, 2004, we are allowed to do that. However, in the recent advertisement, they say that by deleting at least, we are debarred for the participation. Just deleting at least. So here, as you say, Your Lordship, Joyti KK and others, para 9. And I have a citation Joyti KK versus Kerala Public Service Commission.
Judgment को लोग
para 9.
का ज्योति केके के बाद how much water has
Milord will kindly see paragraph 9. Let us have a look into paragraph 9 of Jyoti Keke. In the event the government is of the view that only diploma holders should have applied to post of sub-engineers, but not all those who possess higher qualifications, either this rule should have excluded.
But why do we have to go to this rule when you have said at least? You don't say only. Look at the rules of 2022. Where are the rules of 2022?
Show me the rules.
The word at least was in the 2017.
No.
22 rules has done away with that word at least.
Acha, you have done away with the word at least.
Yes. Page
That word is
57 is the...
So that
And therefore only diploma.
only diploma.
Nothing can be done. I think. And the reasoning given.
The relevant rule.
Just a minute. The petition has to, rules have to be sustained. The rules have to be sustained. MS Denari, the rules will have to be sustained. You are banking on this Jyoti KK and others
Yes.
versus Kerala Public Services Commission.
Yes.
Much water has flown into Brahmaputra.
And I have
don't know
a-
which river flows through this state. Much water has flown in. Now they are very specific that the employer knows.
But in Jyoti, Your Lordship, it is said that it's not excluded. They have to be paranine, Your Lordship. In the event, the government is of the view that only diploma holders should have applied to the post of sub-engineer, but not all those who possess higher qualification. Either these rules should have excluded in respect of candidate who possess higher qualification, or the position should have been made clear that degree holders shall not be eligible to apply for such post when that post is not clear. But on the other hand, the rule do not disqualify per se the holder of higher qualification in the same faculty. It becomes clear that the rule could be understood in an appropriate manner as
I don't understand.
stated above. In that view of the manner, the order of High Court cannot be sustained. In this case, we are not concerned with the question whether all those who possess such qualification could have applied or not. When statutory rules have been published and those rules are applicable, the presupposes that everyone concerned with such appointment will be aware of such rule or make himself aware of the rules before making appropriate application. The High Court, therefore, is not justified the holding the recruitment of the appellants would amount to fraud on the public. So my understanding is that, Your Lordship, in the rules, there is no exclusion of the decree holder. And Your Lordship, 2015 citation also, it's very clear, and I have a 2014 citation. 2015, that is yes, 2015. Parvas Ahmed Peri.
Which judgment are you referring to?
Yes, with regard to the 2015-17 SEC, page 709, Parvez Ahmed Pari versus State of Jammu and Kashmir and others. Here, I'll read from the para 14.
Mukut.
Your Lordship, we do not agree with the reasoning of the High Court that in order to
On
be
this
an
aspect,
eligible
Justice
candidate,
Chandrachud's
the appellant
judgment,
should have done
latest
BSc in
judgment.
forest, and since he had done so, he was not considered as an
Qualification, minimum qualification, and the employer's discretion will matter. What kind of that minimum? I don't remember the citation. Judgment delivered by Justice Chandrachud, followed by Patna High Court, approved by Supreme Court. We'll see it.
And may I read the Lordship, para 15 of the judgment.
Yes.
In our considered view, firstly, if there was an ambiguity or vagueness noticed in prescribing the qualification in the advertisement, that it should have been clarified by the authority concerned in the advertisement itself. Secondly, if it was not clarified, then benefits should have been given to the candidate rather than to the respondent. Thirdly, even assuming that there was no ambiguity or any vagueness, yet we find that the appellant was admittedly having BSc degree with forestry as one of the major subjects in his graduation. And further, he was also having master's degree in forestry MSc Forestry. In the light of this fact, we are of the view that the appellant was possessed of the prescribed qualification to apply for the post in question, and his application could not have been rejected, teaching him to be an ineligible candidate for not possessing prescribed qualification. In our view, if a candidate has done BSc in Forestry as one of the major subjects and has also done Master in Forestry, MSc Forestry, then in the absence of any clarification on such issue, the candidate possessing such higher qualification has to be held to possess the required qualification to apply for the post. In fact, acquiring higher qualification in the prescribed subject forestry was sufficient to hold that the appellant had possessed the prescribed qualification. It was coupled with the fact that forestry was one of the appellant's major subjects in graduation. Due to this, he was able to do his master in forestry.
I didn't bring my book.
Take it on.
And Your Lordship, in this case, we are
You
holding.
are not giving us the judgments of the Supreme Court
I have
of recent origin, judgment by...
2024 I have.
Well, show us. All these aspects have been dealt with.
Yes.
Chandrasekhar Singh.
Your Lordship, that is in page 31, para 31, page 21, wherein, Your Lordship, here also based on the based on the 2015 judgment, para 34.
These judgments will not apply.
Here, Lordship, this is based on the 2015 SEC. Here, para 34. Thus, we have no hesitation holding that the appellant who possessed postgraduate degree in subject cover under RFSS 2011 rules
This is pursuant to some other rules, the powers were given. परी में क्या कहता है That's very this is absolutely uncalled for.
Your Lordship, even in the Joyti KK, it's clearly clarified that the rules should be clearly exclude the degree holder. In this case, Your Lordship, it's just saying that HSLC with diploma holder.
Now, if your Lordship can kindly come to the schedule at page 59 of the writ petition.
Just a minute, Mr. Dev. I'm looking for a judgment which traveled to Supreme Court. It was accepted.
But in the schedule, my lord, specifically it has been mentioned diploma holder. If my lord comes to page 59 of the writ petition, the schedule is there. The recruitment rules for Group B. And in the schedule, it says
No, that we are clear. 22 says that it should be only for diploma holders.
only for diploma holders.
The thing that now they are saying, since they are graduates, why shouldn't they be included? That's all. So we
No,
just see the
if
judgments.
they are graduates, but they have done their graduation after their diploma, they shall be eligible. Higher degree in the same line.
But the problem lies somewhere else also, my lord.
No, but if they have got the minimum
The,
qualification,
the practical problem which is being faced by the government,
They have followed that.
that is also a serious issue. And that is why these rules were amended.
Obviously.
I don't think it's
That's sort of different thing in masters. That's whatever the degrees used, specific execution. It's all a different concept.
Your Lordship, in this case, we are in same discipline, only that we are a degree holder in the civil engineer, even though the rules does not debar, exclude the degree holder. It's just saying that the rule, if you see the rules, only it says that HSLC with diploma holder. That's all.
Take down. We have heard MS Dinari T. as you, learned advocate for the petitioners, and the learned advocate general, and Mr. Bishwajit Dev, learned advocate general for the state of Mizoram.
And my lord, my presence may kindly be reflected. I am
We have-
responding number 6.
We have also heard
JC
Mr. J.C. So-and-so Sangha for Mizoram Public Service Commission / respond number 6. The petitioners have challenged the Mizoram Public Service Commission, petitioners have challenged the Mizoram Public Works Department bracket Group B post recruitment rules of 2022, wherein for filling up the post of junior engineer civil, the educational qualification has been fixed at HSLC with 3 years diploma in civil engineering from government recognized institute. First up, the challenge has been laid by the petitioners who are graduates in engineering, graduates in civil engineering, having secured their respective degree from a recognized university / institution. First up. The reason for the challenge is that pursuant to the rules of 2022, which supersedes the earlier rule of 2017, an advertisement was floated by the Mizoram Public Service Commission for filling up 10 posts of junior engineer civil on contract basis. Stop. Earlier, the minimum qualification, under the rules of 2017, the minimum qualification required for direct recruitment was HSLC with at least 3 years diploma in civil engineering from a government recognized institution. With the change in the rules regarding the minimum qualification, namely diploma, the graduates have been completely excluded from consideration. The grounds on which the rules have been challenged are that a graduate degree is a higher degree, and therefore a person having a higher degree than diploma ought not to be completely excluded for the purposes of appointment, as it violates Article 14 and 16 of the Constitution of India. First off. The other ground of challenge is that a graduation degree in civil engineering has to be considered a higher inline/in-channel learning, which again cannot be completely ignored for the purposes of appointment. First off. An ancillary argument has been made that with the rules of 2022, enforced strictly, the writ petitioners / graduates in civil engineering would lose all chances of employment, which is neither appropriate nor desirable.
They were for setting aside the rule.
Yes, they all challenge the rules, sir. Rules. It was also submitted by M.S. Denari. That with the rules of 2022, the entire service cadre would be filled by diploma holders only. First up. Lastly, it has been submitted that excluding higher degree for the purposes of appointment does not muster the constitutional challenge of a reasonable classification and a nexus with the object sought to be achieved. First up. Countering the aforenoted argument, the learned Advocate General, while referring to the affidavit filed on behalf of the estate of Mizoram, has submitted that there is no gainsaying that a degree holder in civil engineering possesses an advanced qualification compared to diploma holders, but there is a specific reason for the government to enact the rules excluding degree holders from being appointed on the post of civil engineers, junior civil engineers on contractual basis. First up, degree holders more often than not seek and get opportunities for higher position, leading to constantly vacant positions in the department. This trend posed a serious challenge for the government in its department of PWD, na? In the department of PWD for maintaining continuity in the service and carrying on the developmental works. Apart from this, it has been submitted that the past experience of the government has been that with the degree holders in positions, there has been a workplace discord affecting the overall performance of the department. Thus, a conscious decision was taken by the government to limit the eligibility criteria for the purposes of appointment to the post of junior civil engineer to diploma holders in civil engineering to ensure stability and efficiency in the functioning of the department. First up, the difficulty faced by the government in cases of resignations of degree holders getting better opportunities and they thereafter resigning from the posts is the long drawn process of filling up the vacancy after advertising the same. That apart, Mr. Dev, Learned Advocate General, Mizoram, has submitted that it cannot be said that a graduate degree in civil engineering is in the same line of learning as that of diploma. The course curriculum of diploma is different from the curriculum in graduate degree in civil engineering. The relevant some of the subjects may be taught in both the courses, but in diploma course, which is essentially for 4 years, which is essentially for 3 years, there is a greater stress on the field training, which in the past has been found to be more suitable for the post of junior engineer, and that also on contract basis. First, after having heard the learned counsel for the parties and having perused the judgments referred to by the learned counsel for the petitioner, namely Jyoti KK and others versus Kerala Public Service Commission and others, 2010-15 SCC 596, Chandrasekhar Singh and others versus State of Jharkhand and others, bracket civil appeal numbers 10389 of 2024, and there is a Pari. What happened to that Pari judgment?
2015.
And Parvez Ahmad Pari versus State of Jammu and Kashmir and others, 2015, 17 SCC 709.
My lord, I have also relied on Jyoti KK, paragraph 9.
We find that the Mizoram Public Works Department Group B post recruitment rules of 2022 has superseded the recruitment rules of 2017, substituting the minimum educational qualification for the post of direct recruitment to the post of junior engineers as SHSLC with 3 years of diploma in civil engineering from government recognized institution. Under the 2017 rules, the requirement was fluid, and that the minimum qualification under the rules of 2017 was at least 3 years diploma in civil engineering. With the new rules in place, diploma in civil engineering remains the only essential qualification. There is a distinction between minimum qualification and essential qualification. Even in cases of even under the rules where essential qualification is prescribed, there would be no difficulty in persons having essential qualification and higher qualification alongside. However, in minimum qualification prescribed, there are greater chances of people with higher qualification making application. The situation by and large remains the same under both circumstances. Considering the fact that the recruitment process was on, this court directed for permitting the graduate degree holders in civil engineering to be permitted to take part in the examination. First up, Mr. Lal Nuasanga, learned advocate representing the Commission, has submitted that the examination has already been conducted, but the results have not been declared for the reason of pendency of this petition, which essentially challenges the constitutionality of the rules of 2022, fixing the essential qualification for such appointment to be diploma in civil engineering. First up, tested from the angle of the constitutionality of the Act, we find that the state government is within its power to frame rules. First up, this is purely in the domain of the government as an employer, which knows best, what qualification would be most suited for the posts to be filled up. First up, any transgression of the judiciary in that field, unless the rules are absolutely untenable, completely, completely exclusionary and irrational, is not permitted, is not permissible. Full stop. So far as the classification is concerned, to pass the muster of Article 14, the past experience of the government, the suitability of diploma holders, the past experience of the government of degree holders often resigning from their posts, creating frequent vacancies, the suitability of diploma holders for the post of junior engineers, the necessity of diploma holders who are intensively trained in the on-field job the classification so far as fixing the essential qualification of diploma comes within the permissible region, which has an intelligible nexus with the object sought to be achieved, namely filling up of vacancies and effective running of the administration, effective running of the department's function. First up. Any graduate degree holder having a diploma also definitely would not be excluded from consideration. But since essential qualification has been fixed as 3 years diploma, any higher qualification without the essential qualification would not suffice. So the argument of a higher learning in channel is not acceptable, First up, no other cogent ground has been the challenge to the rule on the ground of it being exclusionary is only being noted to be rejected. There cannot be any insistence of a degree holder to be permitted to participate in the recruitment process without the minimum / essential qualification. The apprehension of the petitioners that with this rule in place, the entire rank and file of junior engineers and below would be filled up only by diploma holders ought not to be the concern of the petitioners. The specific averment made on behalf of the state of Mizoram regarding their past experience and the suitability and the rules having been made, which is purely in the domain of the government as an employer, the challenge does not appear to be sustainable. In Jyoti KK, Supra, the Kerala Public Service Commission had invited applications for selection to the post of sub-engineers electrical in the Kerala State Electricity Board as per Kerala State Electricity Board. The qualification prescribed for the post was diploma in electrical engineering or a certificate in electrical engineering from any one of the recognized technical schools with 5 years service experience under the Kerala State Electricity Board. The holders of BTech degrees in electrical engineering challenge those rules as they were excluded from participating in the recruitment process for their not possessing the necessary qualification. The Kerala Public Service Commission held that they were not eligible for selection. The challenge to that decision was primarily based on the ground that a BTech degree was a higher qualification, and therefore such qualification also should have been considered. The High Court of Kerala, while deciding the issue, held that the qualifications possessed by the degree holders did not presuppose the acquisition of prescribed lower qualification, and when qualifications have been prescribed for a post, the same could not be diluted, and persons not possessing those qualifications could not be permitted to be eligible. Permitting it would have resulted in fraud to public. Permitted to be eligible. The Supreme Court, however, observed that when a qualification has been set, however, observed that when a qualification is set out under the relevant rules, the same cannot be in any manner whittled down, and a different qualification cannot be adopted. The observations of the High Court that the higher qualification must clearly indicate or presuppose the acquisition of the lower qualification prescribed for the post. What have I said? Was sustained but it was clarified that if a person has acquired higher qualification in the same faculty, such qualifications can certainly be stated to presuppose the acquisition of the lower qualification prescribed for the post. As noted earlier, as noted in the preceding paragraph, a graduate degree holder also having a diploma in civil engineering can under no circumstance be excluded, but a candidate must possess the basic minimum qualification of diploma in civil engineering. The facts in Chandrasekhar Singh and Parvez Ahmad Parry are different, and the decisions in the Supra Kardana and the decisions in the aforenoted cases would not in any manner bolster up the case of the petitioners. Thus, we do not find any good reason to question the correctness of the rules of 2022 when there is no challenge to the rule-making power, and the classification is sought to be justified on the ground of justified on grounds which has a direct link to the purpose which is sought to be achieved, namely continuity in the service and continuity in the service and continuity in service and effective functioning of the PWD department. The petition thus fails. And is
Lordship,
dismissed.
interim order dated 26/3 may kindly be vacated.
The interim order dated so and so stands vacated.
I'm deeply obliged.
Deeply obliged.
For orders, item 6.
These are appeals. क्या है इसमें?
Just for 6, 7, 8 is just to make the paper books.
पानी इधर बना। ठीक है।
Last part you said there is no challenge to the rules. There is a challenge to
There is no effective challenge, sustainable challenge to it. Rule making power. Rule making power. 1 to 4. We'll come back after 5 minutes. We'll go to washroom. We'll come back in 5 minutes, my lord. We came in 3 minutes. Therefore, it's late. We said 5 minutes. First, AC have come.
Sorry, my lord.
AC
It was
got-
so cold, we took little bit of sun.
Yeah, please control the AC. Make it 25 or 26. Yes.
Lordship, the matter pertains to the issue that person occupying two offices. One under this Chakma Autonomous District Council as an executive member and simultaneously as a member of Legislative Assembly.
Yes.
That is the main issue. Now what happened, Your Lordship, I will take Your Lordship to certain dates.
Please come to the issue straight away.
My Lord, Your Lordship,
Dates would not be necessary now.
My Lord-
Let's have the principle decided.
Your Lordship will kindly come to page number 75.
You please come to page number 209,
My Lord.
the reference.
This was with respect to the Office of Profit.
Read the reference first.
This is a reference dated 19/3/2024, received from the Honorable Governor of Mizoram, seeking opinion of whether Sri Rasik Mohan Chakma,
Yes.
member of Legislative Assembly from 36 Tuishwang Assembly constituency of Mizoram, has incurred disqualification from membership of the Mizoram Legislative Assembly under the provisions of Article 191A of the Constitution of India.
Constitution दे देना.
The aforesaid reference
Now come to 5-6 lines from the bottom.
Pardon, my Lord?
Start from here. Anyway, read paragraph 2.
The aforesaid reference arose out of a petition dated 8/1/2024 filed by Sri Doimoy Devang Chakma, hereinafter petitioner, member of District Council CADC and leader CADC ZPM Legislative Party. The petitioner had stated that as per Rule 11(1) of CADC rules, a member of one district council cannot simultaneously a member of another district council or legislative assembly of a state, and that in case of such simultaneous membership, the person should resign from one or the two posts within a period of 21 days from the date of publication of such member in the official gazette, failing which the seat in the district council shall become vacant. The petitioner further stated that the erstwhile Section 4 of the Mizoram Union Territory Legislative Members Removal of Disqualification Act 1975, which had provided exemption from stated in the reference that subsequent to the receiving of the aforesaid petition, view of the Law and Judicial Department of Government of Mizoram was taken as to whether the respondent was liable to be disqualified on grounds of Article 191A of the Constitution of India for holding an office of profit under the government. Therefore, the Law and Judicial Department of Government of Mizoram provided its view, wherever it was stated that the respondent was liable to be disqualified under Article 191A of the Constitution. Furthermore, it has been stated in the reference that the Honorable Supreme Court has relied on the following factors to hold whether an office is an office of profit under the government. 1. Whether the government is the appointing authority. 2. Whether the government has the power to terminate the appointment. 3. Whether the government determines the remuneration. What is the source of remuneration? 5th, the power that comes with the position. With regard to the aforesaid case, the following observations have been made in the reference with regard to the office held by the respondent. The Chief Executive Member of Chakma Autonomous District Council is appointed by the Governor of Mizoram under Rule 22(3) of the CADC Rules 2002. That the resignation of Chief Executive Member of Chakma Autonomous District Council is subject to acceptance by the Governor of Mizoram under Rule 24(1)(b) of the CADC Rule 2002. That the salary of Chief Executive Member of Chakma Autonomous District Council is subject to the approval of the Governor of Mizoram. The Autonomous District Councils rely on granting
Leave that. The analysis will come later. Come to the next page.
My Lord.
Now read paragraph 6 and thereafter.
My Lord. Considering the aforesaid facts and circumstances, the opinion of the Commission has been sought under the provisions of Article 192(2) of the Constitution. The issue raised in the present reference is twofold. Firstly, whether the respondent, who is a member of Mizoram Legislative Assembly and Chakma Autonomous District Council, constitute violation of the constitutional principles laid down in Article 101 and 190 of the Constitution, which provide dual membership of House. In this regard, it is stated that the Commission can provide an opinion on the ground of disqualification of member of Legislative Assembly is laid down in Article 191 of the Constitution of India. The membership of a local body such as that of an autonomous district council is not a ground for disqualification of a member of legislative assembly. Further, Article 101 and 190 of the Constitution bars simultaneous membership of both houses of parliament, simultaneous membership of both houses of the state legislature, as well as simultaneous membership of parliament as well as state legislature. Thus, there is no express bar on holding simultaneous membership of state legislative assembly as well as the autonomous district council. Furthermore, as stated in the reference is Rule 11 of the CADC, after its amendment in the year 2003, no longer prohibits simultaneous membership of the district council as well as the state assembly or parliament. Secondly, it has been stated in the reference, the Law and Judicial Department of Government of Mizoram has opined to the Honorable Governor that the position being held by the respondent, that is Chief Executive Member of Chakma Autonomous District Council, is an office of profit under the Government of Mizoram and thus attracts the provisions of Article 191A of the Constitution. In this regard,
This is exactly your argument. Now,
Honorable-
look at this. Read.
In this regard, it is stated that the aforesaid opinion of the Law and Judicial Department of Government of Mizoram appears to be contrary to the judgment of the Honorable Guwahati High Court in Hifai and others versus State of Mizoram, WPC 6024 of 2013, which is based on similar facts. In the said matter, the issue before the Honorable High Court was whether the members of the Autonomous District Council, including the Chakma Autonomous District Councils, who have been further elected as chairman, chief executive member in the concerned district councils, are holding offices of profit and thus ineligible to contest the assembly election. The Honorable High Court held that even though the office of the chief executive member of autonomous district councils have been removed from the respective Removal of Disqualification Act, Mizoram Union Territory Legislative Members Removal of Disqualification Act 1975, by way of Mizoram State Legislative Members Removal of Disqualification Amendment Act 2006, the petitioners were not holding office of profit under the state government, as the state government was neither the appointing authority nor the authority to remove them, nor determining their remuneration. Relevant extract of the judgment dated 6/11/13 is reproduced
That
here.
is not necessary. Now come to paragraph 10.
Thus, in view of the aforesaid judgment of the Honorable Guwahati High Court, the office of Chief Executive Member of Autonomous District held by the respondent not an office of profit under the Government of Mizoram.
Now, after having read this,
My lord.
now come to 101 of the Constitution. You are agitating you are trying to whip the dead horse. Now come to 101.
My Lord. Vacation of seats. No person shall be a member of both houses of parliament, and provision shall be made by parliament by law for the vacation by
That's
a
right.
person.
And then similar decision with respect to no two houses of the state.
Yes,
190.
190.
190.
90.
Yes.
No person shall be a member of both houses of the legislature of a state, and provision shall be made by the legislature of the state by law for a vacation by a person who is chosen a member of both houses of his seat in one house or the other. No person shall be a member of the legislature of
Now come to 191.
disqualification for membership. A person shall be disqualified for being chosen, as in for being a member of the legislative assembly or legislative council of a state, if he holds any office or profit under the government of India or the government of any state specified in the first schedule, other than an office declared by the legislature of the state by law, not to disqualify his holder. If he is of unsound mind and stands so declared by a competent court. If he is an
All right, come to E. Where it is not relevant, you can skip that. Come to E.
If he is so disqualified by or under any law made by parliament.
Right?
My lord.
Now read the explanation and 2.
For the purpose of this clause, a person shall not be deemed to hold an office of profit under the government of India or the government of any state specified in the first schedule by reason only that he is a minister either for the union or for such state. A person shall be disqualified for being a member of the legislative assembly or legislative council of a state if he is so disqualified under the 10th schedule.
And 10th schedule is the anti-defection.
Anti-defection.
Now come to 192.
Decision on question as to disqualification of members. If any question arises as to whether a member of the House or the legislature of a state has become subject to any of the disqualification mentioned in clause 1 of Article 191, the question shall be referred for a decision of the governor, and his decision shall be final. Before giving any decision on any such questions, the governor shall obtain the opinion of the election commission and shall act according to such opinion.
So therefore, basically, you are seeking his disqualification because these are two posts. He is also the Chief Administrative Officer of Chakma Autonomous Council, and he has won the assembly seat.
My lord.
Now, assembly seat can be vacated only if it is found that he is holding office of profit or is faced by any disqualification clause, which you will find only under 191.
My lord.
And therefore, under 192, the Election Commission particularly, referenced the case of the respondent that you have chosen to implead. And that is the decision. What other decision are you going to tell us?
Your Lordship will appreciate this. This similar issue came up before the Meghalaya High Court. I would like to put your Lordship kindly look into this judgment. Agnes Carson.
Unnecessary. देखा मैं
But I want to see this Meghalaya High Court judgment.
useless है वो कुछ.
If he, Arun and I do it together.
Yeah. No sir, you are aware of
No,
this.
sir,
इसको आप लिखाओगे.
No, no.
कल घर पर.
You know how to do it very short.
No, these are. Yes.
Your Lordship, same issue.
Maheshwar.
The petitioner said to be a social activist has filed this petition SPIL seeking to raise the issue of alleged dual holding of offices by the respondent number 6 to 13, who were earlier elected as members of the Meghalaya Legislative Assembly on 1/3/13, but then were also elected as members of respective district councils on 4/3/2014. Inasmuch as the respondent number 6 was elected as member of Jaintia Hill Autonomous District Council.
Mr. Borgohain, before citing a case, you must read it totally. Now, we had not seen this, but this is with respect to prevention of disqualification members of Legislative Assembly of Meghalaya Act 1972. This provision has not been deleted like it has been done in Mizoram.
It has been deleted, my lord.
Oh, if it has been deleted, therefore there is nothing.
My
See,
lord, your lordship will... My lord, what happened in this?
look at this. The Act of 1976,
My lord.
disqualification.
My lord.
That provision was deleted in 2006.
6.
So therefore, there is no disqualification for an MLA to remain, if a person remains an MLA and also a member or chairman or executive chairman of Autonomous Council, which is not the case in Meghalaya. Therefore, this judgment, how does it help you?
Your lordship will, as far as in the state of Mizoram is concerned, 1976, it says that a member of a legislative assembly...
Come to 1976.
My lord, your lordship will kindly
Please.
come.
You are flagging a dead horse.
If your lordship give me a...
I will give you hearing as long as you want. We are very, very patient, but we don't appreciate unnecessary arguments. I will hear you as long as you tell us, provided you should attract my,
I will come to that cursing judgment after this, your lordship. Kindly come to
that notification of 76 first.
my lord.
And you got this case listed unnecessarily on the second last day when I'm leaving. You said it is for 1 year.
My lord,
Most of the times you were not there.
Orders, your lordship.
Come. Now, Annexure 3, come to page 17. And not that you are not aware of this, you have filed all these documents.
My lord.
So, now read this. This is the Act of 75, removal of certain disqualifications. So,
My lord.
in this, read 2.
Yes. The office of Parliamentary Secretary to the Government of India or the Government of Mizoram. I am concerned with...
No, read 2, the introductory.
A person shall not be and shall be deemed never to have been disqualified or been chosen as for being a member of legislative by reason of the fact that he holds any of the offices specified in the schedule appended hereto. I am concerned with Schedule 4. The office of the Chief Executive Member, Chairman, Vice Chairman or Member of an Autonomous District Council and the President, Vice President or Member of any Village Council constituted in Mizoram under any existing law or regulation. So, in 1973, 1975, it was not a disqualification.
No, it was not a disqualification.
No. Kindly come to page 918.
Acha, this disqualification was removed.
Removed. This disqualification was removed. Operating portion is page 20. Article 4 of the schedule of the Principal Act shall be omitted. This was done in principle with membership of 1951.
And this disqualification was challenged, put to challenge.
Yes,
The
Your
removal
Lordship
of the
has put to challenge.
disqualification to put to challenge in that Hippay case.
Yes, Your Lordship has put to challenge. I will come to that.
उसमें क्या हुआ?
So it has been restored.
It has been restored.
Earlier provision. I mean, they can.
And that apart, why do we get into this when the matter was discussed? There was a presidential reference and the election commission confirmed. Because disqualification, notwithstanding the rules of 1976 or the deletion of Schedule 4, which again was restored by a Hippay judgment. Now, the disqualification is primarily under 191.
No, Hippay judgment was a different issue.
Disqualification is primarily under 191.
191.
192, who decides? The president. President gave it for reference to the election commission. Election commission says no.
Your Lordship will.
You want us to sit over the judgment of the president?
No. Lordship may kindly bear this thing. Kindly come to page
For some other day.
36, my lord.
We are getting up at 1. There is a bar meeting.
My lord, here in 36,
We will hear you again.
Yes. The removal of disqualification,
that your Lordship which was
that has been set aside. Correct?
Pardon, my lord?
The removal of disqualification and deletion of those names. The deletion of those names by the subsequent amendment made in 2016.
The MLA was being removed.
So, no. CM chairman I was the counsel, Mr. Counsel. I was the one who argued before Justice B.K. Sharma
Yes, Your
with
Lordship.
Justice Arun Dev Chaudhary. We
Yes,
were both
and
together.
Devashish Barua was
We have
also
got
there from
the
the election
We
judgment
have
commission.
got the judgment here.
Yes, sir, we have that. There was the issue was
2013.
the issue was
Hippay
that
judgment.
you cannot contest election.
Yes.
The honorable court said that yes, you can.
So this was set aside.
What do you do? Do one thing. You prepare your notes of argument. For this, we will decide.
But your Lordship, want to give us this note in a day or two, or your Lordship, because
If you want, we can. If you want, we can. Apart from that, on your note, we will hear you.
That can be done.
Hippay judgment, that 2013 judgment, that pertains to contesting an election.
Correct.
It has got nothing to do with Office of Profit.
No. It
He has got nothing to do with Office of Profit now here in this petition, Mr. Dev. He talks about disqualification. Disqualification under 191.
Under
that
191
has been discussed.
And thereafter, under the amendment of 2006, by which clause 4 was omitted.
Because your Lordship will find that in 2006,
And the entire, my lords, the
Mr. Malhotra say something.
Yes, Mr. Malhotra.
remuneration.
If I may, just one submission at this stage. The opinion of the election commission, which was referred by the governor, honorable governor, and on which basis the governor has passed an order on the petition filed by petitioner number 1, has not been challenged in this writ petition. I mean, it has not been
your Lordship, I have
challenged.
explained it in my writ petition.
If your lordship, you can
Have you challenged the
No, I have
governor?
explained it in my writ petition. I am saying that yes, in the Office of Profit, I accept this, the view given by the Election Commission. I am not contesting on that. I am saying that prior to 2006, the chief executive member or member of an autonomous council were debarred. But when 2006 amendment was being brought, the
Page 13
word of
is the
MLA, the office of MLA was being exempted.
Page 13 is the relief claim.
Kindly come to page 36, my lord.
Page 13.
Page 36.
Even regarding the Office of Profit also. My lord,
Page
this ma-
36.
this matter is squarely covered by the Jaya Bachchan judgment.
Sir, both of you are. Look at this. Now, you want his disqualification.
No, my question is that,
Mr.
To office.
Bourgoin, to office and therefore disqualification.
yes, my lord.
Now disqualification, unless he's disqualified, he remains MLA,
My lord,
holding two posts.
2 posts.
Now, the first ground under 191, disqualification if he holds any office of profit under the government of India or government of any state specified in first schedule, other than the office declared by legislature for state by law not to disqualify the holder.
Understood, my lord.
Where exactly do you want us to go beyond this? Or if he is so disqualified by or under any law made by the parliament?
My lord, CADC has brought a law, the state has brought a law. If the state law, CADC's laws is repugnant to the state law,
Which
Yes.
state law? Which state? law?
Mizoram state law, disqualification.
This petition is admitted for hearing. Just list it on some day that I will come again. We will hear it.
Your lordship can take this matter to principal bench.
In the principal.
No, we will come here for hearing this only. List this matter for final hearing on, give a date in January. I'll surely come in January, no?
20?
For hearing and disposal.
21st?
The board stands discharged. वो लिखने की जरूरत नहीं. Board stands discharged. Give a date in that.
Is it 21st of January?
Yes,
2-1.
2-1.
January.
We say board is discharged. Board is discharged.
Item 10.
Your lordship may allow me to make a mention, my lord. The next item, my lord, hearing item, my lord. I am for the appellant. This is a criminal appeal, my lord, a conviction under section 6 of POCSO, my lord. In the last court date, my lord, this honorable court was pleased to appoint amicus curiae, my lord, for the respondent number 2 victim, my lord. And a direction was made for furnishing paperwork, my lord. But I was of the wrong impression that, my lord, paper book will be furnished by the registry, my lord. She has not received a paper book till yet, that, my lord. That was my mistake, my lord.
Registry has to
So,
furnish.
my lord,
The
sometime maybe
registry
give it to
only
me.
has to furnish.
Other time, my lord, the registry used to furnish, my lord, but since this is a private
you-
appeal,
do
my
you
lord,
want to
appeal
do-
by the private,
No, you're for whom?
I am for the appellant, my lord.
You want the paper book?
No, my lord, for the amicus curiae, my lord.
No,
Respondent number-
you talk about yourself.
My lord, I have already received, my lord.
So therefore don't worry about amicus.
My lord, they told me that it is the duty of the criminal appellant to furnish paper.
The registry will give a copy of the
You just
paper.
write registry to furnish a copy of the paper book to the amicus curiae.
My lord.
List this matter for hearing on
After the week?
after a week. Get ready.
12th of November.